Well, good morning, everyone, and welcome to Ground Rules Employment Law over your coffee break. My name's Pam Howland, and I am with Idaho Employment Lawyers, and I'm here today with Christopher Walrath and Doug Class, who are also attorneys at Idaho Employment Lawyers. And we have a special guest today, and our special guest is Megan Egbert. She is a representative with the Idaho Legislature. She represents District 17. And we are here today to talk to Megan about what's going on in the legislature and how that might impact Idaho employers with possible legislation that she's seeing. Megan, we've had the special privilege of getting to know because in addition to being a legislator, she is also a law student and she's about to graduate from the University of Idaho. So congrats, Megan, on not only being a legislator, but also getting through law school. So what we're hoping to talk about today is the state law, the state of it, and what's possibly coming, what's in flux, and how that impacts employment law and employers. And typically every year there's a handful of things that we're on the lookout for, issues that are driven by state law, maybe more than federal law. There's a handful of them that we seem to run across in our practice from time to time. So I'm hoping we can kind of start with that. Maybe those are the easier ones to tackle. And so I just wanted to kind of pick Megan's brain. So one issue that we see that's driven by state law is non-compete. So Megan, are you seeing anything on the non-compete platform this year that employers should be on the lookout for?
Yeah, I think there's some interest in Idaho in talking about, should we allow non-competes? How should we allow them? But there's also awareness of what's going on a larger level. And so I think it's something that you'll hear in that building a lot is like, let's let the courts figure out where they're going to stand on certain topics. And I think that that's specifically one of them. So I think that there's a desire to give people more guidance and understanding of where we're at with non-competes, but also just realizing that it's very uncertain at this time.
Oh, I would love that. That would be cool to have a little more guidance because as we all know, 2024 was a little bit crazy with the FTC proposed rule to ban non-competes entirely. We know that as we approach September, when that was going to go into effect, it did not go into effect, but definitely seemed to signal some type of national move towards maybe not having non-competes. So,
and I would echo that maybe that's how Idahoans would prefer it as well. But I think that there's some areas that would be more affected than others. And so, those decision makers are trying to also, take those into consideration is what fields of practice would really be impacted by these decisions if we didn't have non-competes anymore.
Yeah. So for sure, I would say employers be on the lookout for that on a national level. That's one to monitor. And we tell our clients maybe be thinking about if you have non-competes, do you really want to keep your non-competes or do you want to update them maybe to reflect more of a non-solicitation provision and to make sure you've got non-disclosure agreements, confidentiality protections, but be on the lookout for, whether or not the non-compete statutes we have are going to hold. Okay, moving on to another issue we're always looking out for is our Idaho Protection of Public Employees Act. That's our public whistleblower statute. That's typically found in Idaho Code Section 62102. And that we do a lot of litigation under that statute in defending the state, particularly and other public entities. Are you seeing any year that might impact the Idaho Protection of Public Employees Act?
I haven't heard anything yet, so it's still, it feels like we should almost be done with the session. It's still early. There's still time, but I have not heard anything yet.
Okay. Okay, so that's a good point. So maybe tell us a little bit more about that. Like, how does the legislative session work insofar as, do you have a feel for when it'll wrap up, and when will we know that we've seen all the legislation that's going to come through?
It feels still to me like a learning experience and a bit of a guessing game. They do have a target signing die date, which is like towards the end of March. That means, our last day would be towards the end of March. Nobody thinks we're going to make that. And I think one of the things that you can look at to kind of gauge that is where the JFAC committee is at. So that's the Joint Finance and Appropriations Committee. This is the committee that is made of both 10 members from the House of Representatives, 10 members from the Senate, and then it has 2 co-chairs, one from each chamber. They set the budget for the entire state of Idaho. Meanwhile, while they're setting the budget, we are passing bills that impact that budget. So it's this really difficult dance. And until they are done setting the budget, we really can't know which bills we can pass, although we do still pass some of them through both chambers. But we are a bit behind schedule of where they would like to be with that process. So I think we will be there at least until April. I would be glad to be pleasantly surprised and be wrong on that.
Okay, so we warmed up with some of the easy issues. Now we're going to get into some of the stickier ones. Let's talk a little bit about our Idaho Human Rights Act. And we know that we've got an Idaho Human Rights Act that in many respects mirrors our federal legislation, but in some ways it's different. And last year we had an amendment that went through that related to pronoun usage. So I'm looking at Idaho Code 675909. There was some legislation that protected public employees, and I'm greatly paraphrasing here, but from any type of adverse action if they refuse to use someone's preferred pronouns. And I will say that I did check with Ben Earwicker, who is the executive director of our Idaho Human Rights Commission, back in December, and asked him if he was seeing any legislation or any movement that's impacted that. And he said he'd heard grumblings, but had not really seen anything definitively on that front. So are you seeing or hearing anything about that legislation?
I haven't seen or heard anything about that legislation yet. I will say, like I said earlier about the non-competes, there's oftentimes just this air of let's let the court system figure it out if we think there's a discrepancy between state law and federal law, or state law and case law. For example, last year we also saw the library bill, which I think that was House Bill 710 last year, which was another private right of action for citizens against libraries if they don't like their decision about whether they remove books or not. But what was interesting about the way that Idaho wrote it is they included private. But by the way it was written, it seems like it also includes private libraries in there. So like private schools, and we have a few nonprofit libraries in Idaho. Well, there's now, many people thought that they would fix that this session, because you can't really dictate what those private entities are going to do with their collection. And they chose not to, because there's actually a pending lawsuit about that specific piece of legislation because of the private entities that are included in there. And so they're not going to fix it because they're just going to wait till what the courts say. So I would assume on this one, they might be taking a similar approach.
That's super interesting. We have heard from some clients concern about just confusion, like you said, over contradictory state law versus federal law. And we all know the sarcastic side of me is like, we just don't see a lot of cases. So waiting for the courts to flesh it out might take a bit, but we'll stay tuned on that one too. How about, so we've seen over the last month these DEI initiatives with the new presidential administration, is that impacting the legislature? And are you hearing anything about that in regard to possible legislation or issues that are before the legislature?
Yeah, it's definitely impacting the legislature. I mean, if you look back even 3 years, it's been drastically impacting the legislature. Somebody described it to me right now is that this legislature is now trying to drag up the ghosts of DEI and move beyond just looking for DEI in any public entity. And now we're looking at if they ever have done DEI. It feels a little bit absurd, but if you watch any of those JFAC hearings that I was talking about, when they're talking to university presidents or when they're talking to the Department of Health and Welfare, they're looking for, have you ever spent public funds on these things? Even things that aren't mandatory. When they were talking to the president of Boise State, they were drilling in on a certificate, a completely optional certificate available to students at Boise State. But they are being so careful about whether public funds are going to any DEI. And then I would say the other thing we're seeing is that they're defining DEI much broader as well. When they were, I would say, picking on Boise State in their conversations with them, they were talking about this lecture series where the whole point of it is just to foster civil discourse. It's not even aimed at, diversity and inclusion necessarily. So the definitions seem to be getting broader, and they are very, very focused in.
Yeah, I don't know. Jennifer and Doug, do you have anything?
Well, I was just have a question. You've seen these, I should say, discussions occurring during committee hearings. Do you have any sense whether there will be any actual decisions, whether it's bills or funding decisions? Do you think that the answers to those questions and what they're learning in these interactions are actually going to have an impact and result in some kind of lesser funding, pool of funding, bills?
Yeah, I mean, it always does, right? In those conversations. Sometimes I would say it depends on how those conversations go and how people react to it, and how hard of a stance they will take. But like I said, this year it seems to be going even deeper and deeper, though, where we're looking into the past of what people have done, which seems very unfair. But yeah, so I guess to be determined whether they will continue to take monetary recourse as well for some of those things. But I would not say that it's out of the realm of possibility for sure.
So you talked about the definition of DEI being broadened, and that's one thing that struck me about the executive orders is I'm still not really sure what they mean. So has there been any attempt in the legislature to, in this broadening process, to actually say exactly what DEI is? Anything like that would be helpful for us, our understanding.
Yeah, it would be helpful for my understanding as well. I don't know that they've gotten there. Yeah, I don't think that they have. But what's interesting is I talked about earlier about how we're seeing this trend of let's let the courts figure it out, or and this is one of those areas though where even with an administration that I would say is supportive of this anti-DEI, framework, we're not seeing that same lets them sort out, they're very much this is the Idaho way, we're gonna define DEI however we want in this moment to serve our purpose, and figure it out ourselves. So
it sounds like fair to say we would have to watch both what's happening on the federal level and the state level. It sounds like they're kind of consistent right now, but certainly there could be differences in how the approach is being taken.
Absolutely.
And For those of you listening, we had a podcast episode with Jennifer Hooft, who was here. We spent a fair amount of time talking about those DEI initiatives and what they mean and possible impacts on the workplace. So I guess, what we're hearing is just stay tuned. I mean, it's too soon to say. We don't know. But again, watch federal and state law, too, to see if there's anything else coming from that. We know that is of big interest to HR professionals everywhere and a lot of business owners and employment lawyers, too, trying to make sure we know and understand what those changes look like and what that means for people just trying to run a compliant workplace on a day-to-day basis. Okay, Megan, what else? So I've kind of touched on the big ones that I was curious about. What else are you seeing?
Yeah, so I think just a few other broad topics, that relate to employers. We're seeing a lot of concern about fraud on the behalf of employees in terms of any sort of benefits, like unemployment benefits or workers' comp situations. There's definitely a desire to make sure that there is no fraud in those systems, I would say. And so, for example, we just had one about workers' compensation, specifically about when employees who were hurt on the job get a type of evaluation for like PTSD. So they have a psych or a neuropsych eval. There was a desire to eliminate the ability for a third party observation of that evaluation, so that they could have an attorney record it, or that they could record it for themselves, that evaluation. They wanted to do away with that because there's this belief that could then be shared and that attorneys are going to teach their clients how to beat the exam. So this type of stuff. And another one is for unemployment benefits, we're now going to allow the state tax commission to enter into an MOU with the Department of Health and Welfare, or I'm sorry, not for unemployment benefits, for other benefit fraud. We're going to allow them to enter into an MOU to get their tax return to verify income. Just a lot of concern around fraud. How are we going to, stop fraud? I think a lot of this came from the pandemic, and when we saw increased numbers of workers who were taking advantage of benefits that they hadn't needed before for one reason or another. And just concerns around those numbers and making sure that we were doing things correctly. But there's a lot of legislation around that. And then the final thing I would say is I think we've seen some pieces of legislation who aren't necessarily, the intention isn't to curb private businesses, but it has impacts there. And so just two of the examples that I was talking about was we saw some pieces of legislation, again, having to do with public benefits and fraud around the SNAP program, which is the food assistance program here. This is a federal program. We saw two pieces of legislation, one that would prohibit an individual from purchasing candy or soda while they were on with their food benefits, and another that would require photo ID on their food benefit card, right? The problems with these are for private businesses and for business owners is that the enforcement of it was going to be left up to grocery stores and gas station checkout folks of trying to determine these definitions of what is candy, which has a really absurd definition. It has to do with 10% or more of flour, which is not even listed. They don't even give percentages on labels, right? But because this is a federal program, we can't just make up our own stuff for the federal program. So the only enforcement of it was going to be up to, these small businesses. Same with the photo ID on the card. Well, SNAP benefits go to the family. So how are we going to have a photo of a family on, the card and then expect a rural, grocery store to enforce this? So it's just some not well thought out impacts there. And then the other piece that I think could have some impacts for employers that I would talk about is this conscientious objection or moral objection for healthcare workers. The other two pieces that I just talked about, the SNAP benefits, those I think are both dead for the year. I don't think they're going anywhere, but this one actually is. It passed the House and it's now onto the Senate. This would allow any healthcare provider to object to a medical procedure and not have to participate in it. So this could be anything from vaccines to, I don't know, circumcision. I think you could object to anything. It's not limited. It just says on a procedural basis in any setting. But then it kind of applies this ADA framework to it a bit of where it can't be an essential element of their job or pose an undue hardship to the entity, but it doesn't really give us any language or help of like how we would determine that. So I do think it's kind of expanding the religious objections to an even broader, how do you determine whether something is a moral objection or not? I think that's, part of the challenge with it.
Well, that's super interesting. Some of the things you were just talking to me definitely jumped out at me as impacting ADA implications. Like you were talking about the workers' comp, PTSD framework. I feel like that was only recently approved by our legislature anyway, like allowing PTSD to be recognized under that. But again, just really calling out the need for employers to have a basic understanding of how workers' comp impacts ADA implications and to watch changing laws on that. The other thing that jumped out at me is your comments about the legislature seeking to really crack down on fraud with unemployment and workers' comp. Is I feel like we have had an uptick of intake calls with and people calling and saying, and this isn't work that we handle. So these are cases that we're, referring out, but general scenarios where people are saying the Department of Labor has brought an action against me to require me to repay unemployment benefits, which I don't really recall ever seeing before, that type of enforcement based on fraud. So that's interesting and definitely touches on the employment law arena for sure.
Yeah, we just saw more, we have some ongoing stuff right now from the Department of Labor to actually a few different bills that have to do with unemployment insurance. So it's a hot topic for, really not a whole lot of people. I think right now there's less than 5,000 people in Idaho who are getting benefits from unemployment insurance. So it's actually a pretty small portion.
Yeah, thinking through that moral objection for healthcare workers. So clearly, if you're a healthcare practice, sounds like there's a handful of things that might be impacting your industry that you should be watching for. And what was jumping out at me is, again, the extent to which you need the job descriptions updated and the essential functions laid out. And if you don't have that, it definitely could be a problem if some of this proposed legislation goes through.
Absolutely. And I also think, hospitals being one of them, going back to the non-competes too, people in Idaho thinking through, especially if you're in an area where you're already having trouble recruiting and retaining people, thinking through what are some of those strategies going to be if something does happen with non-competes here in the future, because that's something that all of Idaho is thinking about right now, is how difficult it is to obtain people in specific professions where we're lacking. So,
well, great. Thank you, Megan. Does anyone have anything else before we let Megan go?
I only had one question, and I hope you have an answer, but if not, it's okay. That is, if, for us or for employers or anyone who is wanting to continue to keep tabs on what is happening over at the state legislature, is there a good resource or website that is best to go check?
yeah, I mean, there's a lot of them, but I would say, especially around these topics that we're talking about, I'm on the House Commerce and Human Resources Committee. I would say a lot of this stuff comes through there. That's where all workers' comp, unemployment, PERC, all of that stuff comes through that committee. So that might be like an easier place to watch versus the full everything that's going everywhere bill center. So I would keep an eye on there.
Great. Well, I think that's it for our episode today. Today, we're thinking about non-competes and issues related to that. Doug, who's with us today, is the one who wrote the chapter on that in our Law for Leaders book. We've got it live training, virtual training. We now have our book. All of that relates to the whole realm of employment law topics, including non-competes, including discrimination, harassment, the law related to that. So check in on those resources if you need them. And then again, right before we started our podcast today, we were just talking about how the EEOC is kicking out a lot of very interesting media press releases, which we're seeing multiple per week coming out in conjunction with these DEI initiatives from the new administration. So if you're not getting those, just getting on the EEOC email update could help you understand what's happening with the law and what type of initiatives are, really changing and fluxing with the new administration. So check out those resources too. And with that, we'll see you next time on Ground Rules. Thanks for joining us.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.